Okay, good morning. This is Alejandro Figueroa for the Commission. It is 10:02 a.m., June 9th, 2016. This clarification conference is held in the matter of the verified petition for a restructuring order filed by the Puerto Rico Electric Power Authority Revitalization Corporation, docket number CEPR AP 2016-0001. Also present on behalf of the Commission are Scott Hempling, who will be moderating the conference, Steve Hill, Ralph Smith, and Paul Chernick, whom are all Commission advisors. The purpose of this conference is to address the alternate transition charge design proposal filed by the corporation on June 6, 2016. During the conference, the corporation's representative will answer questions asked by the Commission's staff regarding said alternate proposal. Interveners will have an opportunity to ask questions to the corporation. All parties must keep their microphones muted while not speaking. Parties will not be allowed to speak out of order and may only speak when called upon or allowed to by the Commission. Interveners must ask direct questions and refrain from argumentative statements. Interveners also should refrain from asking questions which have been previously asked by the Commission or any other intervener, or which would result in repetitive answers. This conference is being recorded for public scrutiny purposes, and before speaking, please make sure you identify yourself. Before going any further, I would ask each party to identify themselves. So we're going to start with the corporation. Please identify who is on the call representing the corporation.
On behalf of the corporation, Michael Guerra of the R3 Law Firm.
On behalf of the corporation, Eric Cashman from Norton Rose Fulbright, on behalf of the corporation.
Is there anybody else present from the corporation?
Victor Candelario and Richard Henfield from Quiñones Arbora.
And Michael Mace from Public Financial Management is on.
Ralph Sarumba from Navigant Consulting is on.
Anybody else? Okay, from the Consumer Advocate Office, or ICPO.
Coral Odiot, on behalf of the ICPO.
Thank you. From the State Energy Public Policy Office.
Yes, Jose Maneto from the Office of Energy Policy and
from the ICPR, or Instituto de Competitividad. From Winmar Group. And finally, Dr. Riera. Okay, so for the record, as of 10:06 a.m., no representatives from ICPR, Winmar, and Dr. Riera are present at this call.
Tomás Torres from ICPR is present, representing Fernando Agray.
Tomás Torres.
Yes.
Okay. All right, thank you. I will now turn to Scott Hempling. Please, Scott, you may proceed.
Thank you. Scott Hempling here. The way we'll proceed is our three consultants in series will ask questions for clarification. So Ralph Smith will start the questioning. Then when he is finished, Paul Chernick, if he has any questions, will ask them, and then he will turn it over to Steve Hill I have any questions, I will ask. We will be asking only technical questions to understand the proposal and also to understand how and why it changed. None of our questions should be interpreted as indicating any approval or disapproval. We're simply wanting to understand it. With respect to the legality of the proposal, to the extent there are any issues there, that's not the subject of this call. We will address those, among other things, in the call that occurs at 2 o'clock today. I just want to remind people to turn their mute off if they're not speaking, although probably someone like Zarumba will need to keep it on the whole time so that he doesn't forget that it's off. Ralph, I'll turn it over to you now.
Hi everybody, this is Ralph Smith from Larkin Associates. I will be starting the technical questions on behalf of the Energy Commission advisors. And I basically have 3 documents that I'll be referring to. The first one, probably the document that's going to receive the most attention will be the revised calculation methodology, Exhibit 9.01, which was, I think, provided on June 6th. And that should probably be open in Excel because we're going to be walking through several of the calculations. So I just want to make sure that everybody has that one. The 2 other documents I have are, there's a revised narrative, it's called Calculation Methodology and Adjustment Mechanism to Establish and Adjust the Transition Charge. Up at the right-hand corner of the first page, it says draft of 616 Norton Rose Fulbright US LLP, which is, I believe that is the narrative that accompanies the spreadsheet in terms of laying out the calculation methodology. The third document is dated June 8th, 2016, and it's entitled PrepArc Proposed Alternative TC Rate Design, and that is a 2-page document. It's marked privileged and confidential. Attorney-client communication, attorney work product, and that seems to lay out some of the reasons for the alternative proposal. So I thought before we got into the questioning, I wanted to make sure that the people on the call have those 3 documents in order to reference.
I do. Mike Guerra.
All right, I guess I just had one clarifying question, and that primarily relates to the third document, the PREPA Proposed Alternative TC Rate Design. We just wanted to clarify our understanding that this is an alternative to what the corporation originally had proposed. In other words, the Commission now has 2 items to consider: the original proposal, which had the residential transition charge as a fixed monthly amount, and this new alternative, which has the TC rate design as a per kWh amount for all customers, with certain carve-outs for grandfathered net metering customers.
This is Mike Guerra for the corporation. Yeah, that is a proposal that we've put forth in light of what we, well, really in response to Commission inquiry and intervener concerns. We feel our original proposals. Go ahead.
You're characterizing this as an alternative.
Yes.
Okay, so it's not meant to supersede the other proposal. It's intended to present a choice to the Commission, either the original as-filed one or this new alternative that takes into account concerns that were expressed at the hearing.
That's right.
Okay, good. All right. I guess let's focus next on the Exhibit 9.01, the Excel file that has the calculation model. guess this is probably a question for Ralph Zarumba, but Ralph, can you identify which specific steps in the 12 steps, which steps have now changed under this alternative?
Essentially, the steps that have changed have been, excuse me, referring back to the narrative, just so we could provide some context. The steps that have changed would be that previously we had performed the allocation between the residential and non-residential customers. The non-residential customers would receive a volumetric charge. The residential customers would receive a fixed monthly charge per service agreement. And how that has changed is we have taken into account the residential public housing rate. And
let me just cut you off there to make sure we get through this. Let's focus on step one. There's a change in the wording there. It's changed from bill to usage. This is in the narrative.
right.
The actual calculations for step one change at all in the model?
In terms of the allocation between the two customer groups,
Right.
Essentially, it would only change to take into account the grandfathering for net metering customers.
Okay, so the previous version had the net metering for residential and non-residential included in the denominator, the total,
Yes.
and in the respective numerators for residential and non-residential in steps 1 and 2. Is that correct?
Yes.
And the new method excludes the grandfathered net metering from the denominator in steps 1 and 2, and from the numerator for residential in step 1, from the numerator for non-residential in step 2. Is that what's happening here?
Yes.
Okay, so step 3, the only change was explicitly adding in the interest earnings in the narrative. That had already been included, I think, in the Excel model.
Yes.
Okay, so 4, there's no change in the narrative. 5, 6, 7, and 8, there's no change in the narrative. Were there any changes in the model for steps 4 through 8?
In terms of the payments, no. The assumptions about the payments have remained the same. So that would then follow through with the net revenue requirement again. Same with 6 in terms of collection lag adjustments. Same set of assumptions. Following through to the gross gross billing revenue requirement for the residential and non-residential.
Okay, so the steps where the major changes were are basically 1 and 2 excluded the grandfather net metering from the kilowatt hours in both the numerator and denominator, and then that ends up carrying forward into steps 9 and 10.
Right.
Which are the calculation of the gross billing requirement.
That is correct.
Okay, now let's focus on, so I identified that there are differences in the kilowatt hour amounts that are shown in steps 1 and 2 and the kilowatt hour amounts that are shown in steps 9 and 10. Basically, the kilowatt hours in step 1 for residential, I have 6,263,381,094. And then when residential kilowatt hours are 6,038,177,694. Are you seeing those same numbers?
If you just give me a moment, please. Did you say on step 9 to 6,038,177,694?
Yes.
Yeah, okay, I'm with you.
Okay, so there's a different kilowatt hour number on the residential allocation in step 1 than there is in the residential gross revenue requirement determination in step 9. Now, it looked to me like they were basically, the difference between those 2 kilowatt hour numbers is 225,203,399. That's the difference between those two numbers. I guess I'd add
Right.
that. Okay, and that is basically comprised of 2 different items. There is 13,839,418 for use behind the meter usage for the grandfathered residential customers. And I would just ask you to confirm that.
Yes, I would confirm that.
Okay, and then the other part of the difference is 211,363,982 kilowatt hours, and that is for the residential fixed block public housing customers, and that's described as KWH within the block. Okay, I would just ask you first confirm that that is the other element of the difference.
Yes, it is.
Okay, and then can you elaborate a little bit on what exactly is meant by KWH within the block?
Okay. This refers to the public housing rate, RFR. And customers, they're under that tariff, depending on the size, number of rooms in their public housing, apartment, get a fixed amount of usage for a certain amount of usage for a fixed charge, or up to a certain amount of usage. And that is reflecting the usage that would be covered in the fixed charge. If they exceed the fixed amount for that charge, they are then charged at a different charge, a higher rate, a volumetric charge. So that is reflecting that first block charge depending on the number of rooms in the public housing, in their public housing unit, in their public housing apartment.
Okay, so is the intent then of that part of the calculation to charge those residential clients a transition charge only based on the amount of kilowatt hours that exceed the blocks that are specified in their tariff?
Yes, it was our interpretation of the law that no volumetric charges can be applied to the fixed charge block in the public housing tariff, and that was legislatively mandated. So those customers for that usage would not pay the transition charge.
Okay, so any KWH usage that's within the specified blocks would be exempted from the transition charge, and the same residential transition charge that was calculated for all residential customers as a group then would be applied to their usage in excess of the block. Is that how it would work, or are we missing something?
Okay. They would pay the transition charge for only kilowatt hours in excess of the block. If their usage equaled the block or was less than the block, they would escape paying the transition charge. So if you think about it, there is a first block for each, dependent on the size of the apartment, that would be exempted, and then excess usage, which would not be exempted. That's just stated in a different way.
Okay, so for their excess usage, they would be charged, the same per KWH residential transition charge as all other residential customers. Is that the way this is supposed to work?
That is correct.
Okay, and the residential charge that you calculated, at least for the initial, billing cycle, is 3.166 cents per KWH?
That sounds right. Just give me a moment, please. That is correct.
Okay, so all residential customers, other than the public housing customers, and public housing customers with usage in excess of the specified band would pay the 3.166 cents.
Yes.
And the grandfathered net metering customers would not pay the 3.16 cents on their grandfathered net metering usage. Is that the way it works?
Yes, and it was, we may want to just clearly define, that is essentially the grandfathered net metering usage is for those customers that have a service agreement before the date of the commission's order, and that's essentially usage that is offset by the distributed energy resource. Any excess usage that they would consume from PREPA would be subject to the transition charge.
Okay, and the excess usage will be measured by their meter, right? You don't have to estimate the excess usage, or do you?
No, that would be metered. That would not be estimated.
All right. A similar series of questions concerning tab 2 and tab 10. You also have a different number of kilowatt hours in tab 2 than you do to tab 10. And let me just read those numbers off and you can confirm. Tab 2 you have for non-residential 10,315,313,661 kWh.
That is correct.
And then on tab 10 you have 10,270,239,202 kWh.
That is correct.
And the difference there is 45,074,449.
Yes.
Okay, and I've identified that that entire difference is all usage of behind the meter customers that would be grandfathered.
That is correct.
Okay, and then, so using that different KWH number for net metering on tab 10, you calculate the gross revenue requirement for non-residential. And that calculates out to 3.0666 cents per kWh.
Yes, I agree.
Okay? And then, okay, so tab 11 then is just to recycle through the calculations for the next quarter. And
Correct.
tab 12 is the rate comparison, and that's kind of like a double check on the math and the revenue requirement. This alternative calculation methodology results in a different per kWh rate for residentials and non-residential.
Yes, I agree with you.
I guess, can you explain why that is occurring? Since I think there was some testimony at the hearing that, I think it was actually you when you were asked about if if the transition charge were calculated on a per kWh basis, I thought your testimony in the hearing was that it would be the same per kWh rate for both residential and non-residential.
That is correct, and I remember that question. And I'm going to suggest that the original proposed approach was somewhat simpler, and we've added 2 levels of complexity in the revised approach, with 1 taking into account the grandfathered net metering, which is different levels for residential and non-residential customers, and 2, changing the residential proposal from a per service agreement to a per kilowatt hour rate, but then not assessing that rate to the public housing customers. So those 2 changes to the calculation methodology then provide a result that will not be mathematically equivalent or necessarily for residential and non-residential customers.
All right. Would there be some way on, perhaps on tab 12, to derive a rate that would be the same? I realize that's not what's in your calculations at this point.
We would have to reformulate the methodology, and what I'd like to do, if we do that, is to not do it on the stand, but essentially, the answer is yes, we can do it, but I'd like to submit that after we've had time to quality control check the calculation.
Okay, would tab 12 be the, or step 12 be probably the best place for incorporating that if you were to do it?
Maybe. I'd like to think that through, and that's one of the reasons I would prefer not to do this on the fly. In the interest of quality modeling. But can it be done? Yes.
Okay, would you see any merit in having the same per kWh apply to both?
There is potentially some merit. I think with any of these proposals, there are advantages and disadvantages. This is a relatively small change, and intuitively, it is my opinion that I don't think either the existing methodology or the revised methodology that would provide the same per kilowatt hour charge would ever differ significantly. And the one caveat might be is if there was a significant growth in the number of customers served under tariff RFR. Otherwise, the only difference is essentially the distribution of grandfathered behind the metering usage, which at the date of this order, that would be locked, and probably is not going to be a significant number. However, the RFR tariffs could change over time, and I don't really have an opinion, as to how significant that might be or insignificant it might be in the future. So, in terms of equity, I think there's an issue. Essentially, the transition charge is being allocated based upon the original proposal was a volumetric allocation between residential and non-residential customers. The question is, should the residential customers be paying for the transition charge not captured by the first block of the RFR customers as a policy decision? that could be argued that maybe it should be either socialized or it should be it should be maintained within the residential class. I think either argument could be made. One issue that I will remind the commission of that I said several times in my initial cross-examination is that the total customer impacts of the transition charge are really going to be part of a wrapped rate with the permanent rate that has been proposed to the commission. So we have to also take that into account, and that's where cost allocation is really being addressed. I don't think it is appropriate to really get into cost allocation debates, in terms of just looking at the transition charge in isolation. Now, that was my position initially in my initial testimony. That is still my position.
And I think, would you agree that having the transition charge as a per kWh to residential customers actually provides PREPA and the commission more flexibility in the rate case for working out the residential rate design?
Okay, I can see why you have that opinion.
Okay, do you have that same opinion?
I think the rate cases where rate design should be debated, and I'm sure that the commission advisors have their opinions. My advice and the PREPA management have opinions that may differ, but I think we we may have differing opinions, but I think we all have the same opinion that is probably the better forum for those debates.
So by having the transition charge as a per kWh charge to residential, that leaves the matter of setting residential fixed charges entirely in the rate case where you would agree it more appropriately belongs?
I think it could work either way. I mean, I still think our original proposal was reasonable. We've had these issues, two issues that came up during the hearing. PREPA has asked me to prepare this proposal as a response. We have done it in a way of trying to work with other parties, including the commission's advisors. So, do I think that the original proposal was reasonable? I still do. I think that I'm looking at this as potentially enhancements. And I'd like to defer any discussions about terms of what the final rate design looks like until we have our debates in the next proceeding.
So what would you, in terms of the alternative proposal versus the original proposal, what would you see from your perspective as the pros and cons of the alternative? How is it better than the original proposal, and in any respect is it not as good from your perspective?
I think there is an advantage, is that we are addressing the issue of the grandfathered net metering, which was not addressed in the original proposal. So I think that is definitely an advantage. And there would be then some question about how do you implement grandfathered net metering if there was a fixed residential charge. I don't think there really is a problem with the non-residential customers. There's then the complication, and we always struggled with this in terms of low income. And how do you address the multiple low income tariffs in terms of the transition charge? The commission asked questions about a two-tiered transition charge, which very frankly I thought was intriguing, and I thought was a very good recommendation from the advisors. I think there is still a complication with the two-tiered in terms of the net metering.
So those
I'm sorry.
I'm hearing those as pros or advantages of the alternative. Is that how you are seeing it, that those two items are advantages for the alternative?
Well, there's advantages and disadvantages. I think there's also a disadvantage with the, there could be construed as a disadvantage with the volumetric in terms of, you know, there are certain low-income groups that are large users. There's definitely a disadvantage there, but again, we can try to fix that in the rate case with the permanent rates, with a new rate design. And that's why I'm going to argue that looking at issues such as bill impacts and taking a look at issues such as rate design are better deferred. You brought up a question, and you know, I will take it on head-on right now that I think maybe you were a little that maybe the Commission's advisors may have had some concern that the per-service agreement might have been high, enforcing some issues with the fixed charge. I am not as concerned about that, but that could be construed as an advantage from that point of view. I think the per-service agreement approach was simpler. And that was, you know, when we were working with bondholders, advisors, that was one, and the advisors on the securitization, that was one of the issues that we, you know, were very concerned about, was simplicity and being able to apply it in such a manner that it could be reasonably administrated and ensure that the debt service would be paid over the next 25 or 27 years. So, with all that being said, and that was probably a much more long-winded answer than you deserved, I apologize. I think any of these approaches have advantages and disadvantages. I think that we have made some progress with the new proposals, and there is a preference for the volumetric proposal from the management of PREPA.
And the corporation is on board with that?
Yes. I apologize, I misspoke. I meant to say the corporation.
This is Mike Guerra, can I interject it? Just a clarification that formal board approval is something that we're seeking to have, I believe, Monday. But we expect them to approve.
And would you expect any problem if there was a slight alteration so that the same per kWh charge was applied to all customers paying the TC?
I would consider that a relatively minor change.
In other words, that wouldn't interfere with the administration or collectability of the TC?
I don't think so.
All right. I think that completed most of my questions on the Excel file. And actually that completed my questions on the narrative as well. So I think the next person that, if I didn't ask everything, I think it was going to go to Paul Chernick, if he had any additional questions. And I appreciate the answers. That was very helpful.
Thanks, Ralph. I do have a few questions. The first one is a very general question about how the CILT, the contribution in lieu of taxes, affects the kilowatt hour numbers in Exhibit 9.01. And it was my understanding that the CILT was it consisted of payments to municipalities in lieu of taxes. And I wondered whether you could explain why there are different numbers for kilowatt hours with and without CILT.
Of course. And the issue is that PREPA is acting in two roles with SILT, I think is the easiest way to to understand this. They are acting as a tax collector for the municipalities, and they are also acting as a service provider. So essentially, any silt that is owed to the municipalities is offset from bills. So therefore, that has been reduced rather than to say that there's going to be this round tripping of the money. So if a municipality's bill is reduced 40%, let's just take that as a hypothetical, essentially 40% of the kilowatt hours, 40% of the dollars are offset through silt payments. 40% of the kilowatt hours are offset.
Okay, so the silt is the silt always provided in the form of an electricity discount as opposed to a cash payment?
That is my understanding.
Okay. And rather than viewing that arrangement as a discount, the calculations view it as some non-billed kilowatt hours.
That is correct. I think that's a way of viewing it.
So would there be any inconsistency in just using the total kilowatt hours in your calculations and charging the TC on, or allocating the TC on all kilowatt hours?
I think there would be a problem. I think the problem would be is that the municipalities have a severe payment problem. And if we were to view that if we were to use your approach versus the approach that it was used, it would increase the level of uncollections. That would cause, you would have a decrease. If you think of the TC calculation as a numerator and a denominator, what you're recommending would have an increase in the denominator. But the numerator would also increase because the level of uncollections would increase. So at the end of the day, would that make a difference in the calculation? I suspect there are some subtleties, although I'd have to work through it. But it would, it's
Are you in the middle of a thought?
There's also, I think there are some issues with the legislation in terms of how this would be treated. There might be some legal issues, although I don't want to opine on legal issues because I'm not an attorney. But
okay, I don't think that was our purpose here today.
Okay, yeah, just
Okay. So you're suggesting that if you included all of the kilowatt hours delivered in the allocation, then that would imply that when you set the rate per kilowatt hour, you would have to apply that to the municipalities, and that would just add to their payment problems.
Right. And it would, essentially, it would increase the denominator, but it would also then trigger an increase in the numerator because the revenue requirement would have a higher level of uncollectibles, so our target rate would increase. So I suspect that at the end of the day, the resulting calculation would not be significantly different, although until I would make those changes in the model, I don't want to make that a firm prediction.
Well, just as you exempt, well, let me just ask, is it necessary to use the same kilowatt hours for the allocation between residential and non-residential as you use for taking the dollars to be collected from non-residential and turning that into a cent per kilowatt hour charge.
I want to make sure I understand your question. So you're saying is that could those be the same kilowatt hours?
Or could they be different? I've heard you say if you include the silt credit as kilowatt hours in the initial allocation, you would also have to charge the TC to all of the municipal's usage. And I'm just asking whether you could do the calculation so you did the allocation using all kilowatt hours consumed for residential and for non-residential, and then when you worked out the non-residential rate, you exempted some kilowatt hours from the denominator, including the SILT credits for the munis.
I think you could always do a calculation. The issue is what would be the impact. And as we're talking this through and as I'm thinking about this, I think the result of not using silt would probably be a higher charge relative. I guess I'm going to take that back. I don't want to predict what would happen until we actually did the charges. You know, the model is, this is not a simple model. It's not an extraordinarily complex model, but I'm not sure on the fly I could predict outcomes.
Okay. Okay. Oh, and I had one very minor question, and that was that there's some adjustment for silt on the residential side as well. It's quite small. But do you understand why there are silt discounts on the residential side?
What are you referring to, a specific tab or formula?
Yes, I am.
That might be helpful.
The exhibit 9.01 in the timeline sheet, starting with cell I-51.
Okay, hold on just a moment.
And we're talking about differences with and without silt for the residential, only in the tens of thousands of kilowatt hours, but
I actually have 901, and you said that was
the timeline sheet.
And it was I-51?
Yes. That's where that block of data resides.
We may not be looking at the same version of the model. Was this the original model or the one just released?
You know, I may not be looking at the same one either.
I think I figured out what your.
Okay, excuse me. So
I think I figured
starting
it out.
with I-54.
Yes, I just.
It's the next little table down. There are slight differences between residential kilowatt hour with silt and kilowatt hour no silt. As I said, this is not a material difference, but it seems.
Yes, and I'm going to have to get. I would like to respond to that in an information request.
That seems like a good idea.
This is going back to source data that we received from PREPA.
Okay.
And I'm going to have to. I just want to double check that rather than give you a what may not be an accurate answer on the record.
Excellent. Okay. All right. The other thing that I wanted to ask about was the net metering. And as I understand it, net metering refers to customers who return energy to the PREPA system from generation behind the meter and receive a credit for that. Is that what we're talking about here?
Yeah, well, and that, okay. Well, they do not, well, net metering customers are the smaller net metering customers only have a single meter. Larger customers would have multiple meters, but a lot of the smaller customers only have a single meter. They would only be returning usage to the system if the output of their generation, their DER unit, exceeded their internal usage.
Okay.
Okay.
Yes, that was what I was referring to.
Okay.
And for the larger customers, you have 2 meters, so you can keep track of what's coming into the customer and what the customer is providing back to PREPA.
That is correct.
And you still call that net metering.
Yes.
And do you do the same thing for the larger customers? In effect, even though the meter's not running backwards, you take the difference between the 2 billings for determining the energy consumption.
Yes.
Okay. Is it possible to have generation behind the meter that's not net metering because the generation never exceeds the building's load, or because the customer has installed the control system so that it won't feed back to the system, to the distribution system?
Well, in that case, the meter would be showing, and the terminology that I generally use, that might be helpful, is we talk about net and gross usage.
Mm-hmm.
Gross usage is the consumption of the customer ignoring any distributed energy resource. Net usage is that usage measured at a single meter point. So essentially that would be gross usage minus any usage that is offset by the distributed energy resource.
Okay. Well, the question I was getting to is it the corporation's intent that all behind the meter generation pay the TC on the power produced from their DER, or only those that have formal net metering arrangements with?
Okay, and let's clarify that we're not talking about grandfathered here.
That's correct.
Okay. In that case, the TC would be applied to gross usage. So it'd be all consumption, ignoring the output of the distributed energy resource.
And that would apply to all distributed energy resources, whether or not they were actually in a net metering arrangement with PREPA. So as long as PREPA knows that there's some generation on the customer's property, the objective would be to bill the TC for that generation, even if there's no net metering formally involved.
Yes, customers would pay it based upon the gross usage.
Okay.
The exception.
So I understand the part about gross usage.
Yeah.
What I'm not clear about is where you're putting the dividing line, and there's a lot of discussion of net metering, which may be by far the most common case, but especially with a TC being charged on gross usage for net metering, I'm thinking, would some clever developer come up with a way of having DER that used maybe storage and some interconnects and some other controls, so that it didn't have to tell PREPA we're going to send power back to the system, and it would never send power back to the system, so it wouldn't be a net metering customer. It would just be a reduction in the customer's load of the meter. And if they're not a net metering customer, are they still covered by the TC for the group?
Okay. First of all, if they were doing that and they did not register with PREPA administratively, I think that would be an illegal installation of generation, regardless of how it was designed and set.
So they have to tell PREPA for safety reasons for the grid?
Yes.
Okay.
Two.
So they tell PREPA, we're not going to net meter, but we will have our own generation, and we'll either isolate part of our load when that generation is operating, or we'll have various control systems so that we never send power back to you.
I don't think that was allowed. They'd be considered a net metering customer.
Okay.
And they would, any internal consumption, regardless whether it's self-served or served by PREPA generation, would be subjected to the transition charge.
Okay.
And that is, I believe, specified in the Act.
Okay. Now, getting to the realities of billing the non-grandfathered net metering customers, you said that currently small customers like residential would have a single meter that just runs in two directions. Your kilowatt hour shown on the meter go up as the customer uses energy, and when it feeds power back to the system, the meter just runs backwards and the counter goes down. Is that what you were saying?
Not quite, but PREPA systems basically could indicate when there's feedback into the system, and they could identify it.
Okay. That gets to my question. So, in other words, in the draft restructuring order revised from the 7th of June, in paragraph 45, there's a sentence that reads, initially that amount will be measured without any subtraction to the amount of energy generated by the meter and exported to the grid, and will reflect electricity flowing to the customer on PREPA facilities. So what you're saying is for all the net metered, all the new net metered installations, just doing them the way PREPA does them now, PREPA will immediately be able to say, we'll give you the full retail credit on what you're selling back to the, or sending back to the system. But we're not going to give you the TC on that, and you can keep straight the flow into the customer and the flow back from the customer to the distribution system.
Yeah, I would refer any questions about the RSA to Mr. Tashman. However, yes, that is my understanding how it would work for the non-grandfathered customers.
Okay. I guess it's not a question about the RSA, it's a question about what your understanding is PREPA can actually do with its metering.
Right.
Yeah, go on.
Yeah, and we've had discussions about that, and PREPA seems to be fully capable to be able to address the metering and the billing changes that would be required.
Okay. The second part of that, or the next sentence in that paragraph that I was referring to before, paragraph 45, refers to measuring the output of the distributed generation and charging the customer for the sum of what they receive from PREPA and what they receive from their own generation. And I take it that for some of the existing customers, existing net metering customers, who are going to be grandfathered anyway, that would not be possible without new metering. And
well, the grandfathered customers would not be impacted.
Right, exactly. I'm talking about the technology that exists, that the PREPA has been using on net metered customers. But for new net metered customers, is PREPA thinking that it will have to switch to a more complicated net metering metering arrangement, a new metering arrangement for net metered customers?
It would be a new metering arrangement, yes. PREPA they did an upgrade of their systems a few years ago. They seem to have some good capabilities, so I don't think it's anything that would be too challenging. It's just recognizing the differences that it will, that will exist with the new rules.
So they would have to have some kind of metering device on the, say, the PV panels, so they would know how much, or the inverter from the panels, so they would know how much was flowing to the customer from that, and then add that to the net flow from PREPA to the customer.
There would need to be some type of technology, but I have to admit I'm not an expert. I'm not an instrumentation engineer, and don't want to pretend that I can answer the details of equipment.
Yeah, that's fine. In your discussions with PREPA, did the subject of cost and who would bear the cost of this more sophisticated metering arise?
That is more of a rate case issue.
Okay.
But it would be my opinion that this would essentially be part of the interconnection costs of any sort of PV equipment. And I know that there are some issues with that, with PREPA, and there have been policy issues. I think traditionally they have essentially done interconnections in some cases for free. They're recognizing that they can't sustain that policy. It's too expensive.
Okay. All right, I think that concludes my questions. And Steve Hill, did you have anything you wanted to ask?
Well, it's just a couple questions. It's very, very limited. And Ralph Zaruma, since you're on the stand here, I'll continue with one question for you. And speaking of being on the stand, during the hearings, during the live hearings down in San Juan, we were discussing the impact of the kilowatt-hour charge would have on low-income customers, and specifically the RFR class. And I believe you even had a handout that showed that the impact, the per kWh impact on that class would be significant. And I think the term you used in the hearing was that they would get hammered by per kWh. And I understand from the discussion and from reading the material you provided, your intent in charging beyond the block is to moderate the hammering of the low-income rate class. My question is, have you done any sort of numerical analysis to gauge how, if you will, unhammered they're going to be with this new proposal?
There have been some preliminary analysis performed, but given Mr. Smith's questions, I think what we could do is that if you make a formal request, he asked for a recalculation of the TEC for residential and non-residentials who are the same.
Yeah.
I'd be willing to include that analysis based upon that request, or the original request. I guess it's up to you, and that information can't be provided.
Okay, but let's say, and I don't remember the number that we discussed in the hearing, but let's say that the rate impact to the rate class was 80%. You were estimating, and I don't remember if that's the number or not. Then if you could come up with some sort of comparative figure to what it would be under the new proposal, that would be good.
Of course.
Okay, and then the only other question I had to do with the calculation methodology, the narrative, and let me try to get that up on my screen. And I don't know who the best person to answer this is, because it has to do with language. And it's on page 2 and page 3. You seem to have different definitions of fixed block public housing. On page 2, the usage you define for fixed block public housing as kilowatt hour usage includes the full consumption of such customers, whether within or outside of the base block. That's on page 2.
Okay.
All right, and then on page 3, you define usage for fixed block public housing as KWH usage beyond the fixed block. Now, my question is, why is that different? And the second question is this have to do with the questions that Ralph Smith asked you about the differences in the totals of the residential kilowatt hour sales and kilowatt hour build between tabs 1 and tabs 9 on Exhibit 901. Is that the same issue?
That is the same issue, and the differences in the kilowatt hours essentially is those within a fixed charge block that would be excluded from the TC, be having the TC applied, and those that are in excess, if there is any for a customer,
okay, well,
the TC would be applied.
All right, I understand that, but you see on page 2 in the middle of the page, in the paragraph, do you have that document calculation methodology?
Give me a moment.
Okay.
Mr. Hill?
Yes.
This is Eric Tashman from Sidley. Maybe I can elucidate here.
Please, thank you.
Sure. That's fine, Eric. In the middle of the page, the paragraph begins, quote, actual kilowatt hour usage, unquote. The second sentence says, for fixed block public housing customers, actual KWH usage includes the full consumption of such customers, whether within or outside the base block. And then one page later, on page 3, several paragraphs down, the paragraph defines fixed block public housing customer usage means just the kilowatt hours beyond the block. So that seems a bit confusing in reading it, and I wondered if maybe that you should say why those two things are different in the document.
Oh, I see what you're saying. Well, these are definitional. We'll review this, and I think it works. But let me explain the difference. The actual kilowatt hour usage on page 2 includes includes the gross, includes within and with outside the block, because for the purposes of the first calculation, the allocation of costs, we use gross usage.
Okay.
So when you get so we have to define a new term for residential usage, and the use for determine how we calculate the kilowatt hour charge when we need to net out basically the usage that's only, so we only want to use excess usage for those block customers. So perhaps the nomenclature, it gets a little confusing, but the only use of that term fixed block public housing customer usage is within the term, I believe, eligible residential kilowatt hour usage.
Yeah.
And that's where that term is used. So it was used, we can provide the definition, but the point is that second definition is used, fixed block public housing customer usage is used only to derive the next definition, which is the eligible residential kilowatt hour usage that is used to determine the TC. So I'm sorry about the confusion, but there is a difference between actual and fixed block public housing customer usage. Maybe the terminology we can revise the definition to make it, but that's the reason why the usage definitions are different.
Right. I understand it better now after the explanation earlier. That was my assumption, but it seemed to be confusing just reading it. One is for the allocation purposes, counting all the kilowatt hours. The other is for billing purposes. How are you going to actually bill the TC? And you only want to bill those customers on the excess usage they have. That's the idea.
Correct. You only want to bill when you calculate the residential charge, you want to aggregate only the usage that is subject to the charge.
Okay, so that mitigates the impact on that RFR group, the non-hammering that we were talking about earlier.
Correct. The allocation formula, the gross usage is used to allocate to the residential class, but once you're in the residential class, and once the cost allocation is completed, then what happens is you reduce the usage by only to those kilowatt hours which are subject to the charge, and then you divide by that reduced usage.
Right. I got it. And those are my questions. Scott, I'll turn it back over to you.
Yeah, Scott, before you take it, this is Ralph Smith. I had one, I think it's going to be a fairly simple item I want to direct to Ralph Sarumba.
Yes,
Ralph, you still here?
I'm here.
Okay, do you still have the tab 12 pulled up on the spreadsheet?
I'm there.
Okay, while Paul and Steve were asking their questions, I was looking at the tab 12, and we were talking earlier about a potential easy way of calculating a uniform per kWh charge that would apply to all transition charge eligible customers. And looking at tab 12, if you add up the adjusted kWh's, which would be line 12 and 25, I got 1,895,853,733, and that same number appears in all four columns because it's the same numbers being added. Okay, you follow me so far?
Yes.
So that's like the combined residential and non-residential total adjusted kWh's, and then the total revenue by ratepayer is shown on line 25, and that again is broken out for each of the four rate periods under consideration. For this particular one, it's being driven by rate 4. So when I divide that $58,849,580 amount by the combined
Scott Hempling here.
adjusted kWh's, I get a rate then of 3.104 cents.
I'm following what you're doing. It makes sense, Mr. Smith. I just want to make, I think that makes sense, but I don't want to confirm that until I go through the model.
I didn't necessarily want you to confirm. I just
Yeah.
wanted to suggest that type of additional line item and additional division for your consideration as a possible way of coming up with the a uniform per kWh transition charge rate.
No, I agree with you. Thank you for pointing that out.
Yeah, so just take that back and think about it. I'm not asking for a conclusion today. I guess you can provide that once you've thought it through.
Very good. Thank you.
All right, thanks.
Ralph, are you done? Scott here.
Yeah, I'm done, Scott.
Okay, Hempling here. Just one point, not a question, then I want to turn it over to Commissioner Rivera. Mike Guerra, what will be important is when you next communicate, which I assume will be the brief, that you state whether you're presenting to the Commission two alternatives, either one of which you say the Commission is free to choose under the statute, or whether you are withdrawing the original alternative, the original approach, and proposing only one, because you have the, as far as I understand it, unreviewable discretion to elect under the statute, and so we'll need to know exactly what it is you're presenting to us. Mike, am I clear?
Yes, clear. We'll
Okay,
make sure that's clear.
Commissioner Rivera, did you have a question, sir?
Yes, Scott, thank you very much. It's going back to the seal discussion, Mr. Zarumba.
Yes.
It's something that wasn't very clear to me. On the timeline tab of the Exhibit 9.01, the revised R1050C model, do you still have that, sir?
Okay, I'm at the timeline tab.
Okay. On cell H174, it lists there the base actual/customer usage for non-residential base customers. The number is 10,211,129,921 kilowatt hours. You see that?
Yes.
Okay. My question is, does that total include the municipality consumption in excess of still?
I am checking. May I respond to that as a request, as an information request?
Okay.
Take the time of the commission and to go through the model. I think it's probably better just to be put into a request. Just the time it would take to go through the model, point out everything that's gone through, and also just in case we have to get clarifications of input data from PREPA.
Okay.
I'm not trying to debate your answer. I'm just trying to make sure it's answered accurately and completely.
Okay, I really appreciate it. The reason I'm asking is because of the definition of client on Act 4, Article 31. Essentially defines the municipality as a client whenever they exceed their tilt allocation. So I wanted to verify that actually we're accounting those, or what we're expecting that number to be. So I appreciate it. Thanks.
Okay, very good.
Okay, so now we believe the commission has finished asking questions. For the record, this is Alejandro Figueroa. We'll now proceed to any interveners who have questions for the corporation. Before going to interveners, I will call on each intervener and grant them an opportunity to ask questions. Once again, we ask that interveners ask direct questions and that the questions made are in relation to the discussion we've had today and are not repetitive of questions or subjects that have already been raised by the commission staff and answered by the corporation's representative. So first, we're gonna ask if the consumer advocate has any questions for the corporation.
Good morning, this is Corrado Diaz. We don't have any questions for the corporation. Thank you.
Thank you. Next, we will ask if the State Public Policy Office has questions.
Yes, this is Jose Maeso from Energy Policy Office. I just want to, we just want to clarify in terms of the grandfathering, if either the law or any other statute gives the commission any power to, in terms of the grandfathering, to allow that to expire at some point other than the 25 years that I think it says in the law, or 20 years. I don't remember what is the number that says in the law, but is there any possibility that when you are adjusting the mechanism, that grandfathering could go away?
Are you asking my opinion about the definition of grandfathering in the law and how it is reflected in the calculation methodology? Are you talking about a actual mechanical part of the calculation?
No, it's just in terms of the concept that that this could be adjusted for certain conditions, or it will be reviewed every 3 months, or as the law says. If in any of those cases there's a possibility that
because, for example, of the revenue has been reduced significantly for some reason, then the grandfathering could go away because of one of those reasons.
I think that question might be better directed to Mr. Tashman.
Before answering, we're gonna have a discussion there's a 2 p.m. call scheduled to discuss the draft order. That might be a subject that it would be better off discussed during that call, as it relates to how the grandfather clause in Act 4 will be interpreted for purposes of the restructuring order and the restructuring resolution.
Okay, so we'll take the question there.
Do you have any other questions?
No, not at this point.
Thank you. Does the Instituto or ICBR have questions?
Yes, we do. Thomas Torres for the record. In the original request, the attachment 3.03, it says that the total restructured principal amount will be $6.84 billion. But then in revised order, it doesn't give a specific amount. It's to refer to $4.97 billion that will be issued for PREPA bonds that are not insured. And then there is another amount of 2.086 for the monoline meters. And then it refers also to, in letter E of the finding tax issuance of bonds corporation, 2.6 billion. We just wanted to clarify that the new amounts here is a breakdown of the original amounts proposed to be restructured, or if this is a breakdown that is being proposed of the amount to be restructured change on the new proposal.
What document are you referring to in the?
Okay, the first document is the original order, attachment 3.03, is page 1 of 4. It's a principal balance of 7/1/2006, July 1st, 2016. And then in two places, it's more than one mentioned on the appendix 1 draft restructuring order. It mentions several amounts to be restructured. It mentioned 4.97 billion, 2.086 million, and 2.6 billion. We just want to, since there is not a chart presented as on the original request, we just want to clarify what is the total amount to be the proposed structure amount on this new revised document.
This is Mr. Tashman. With respect to the, I can't actually, I'm not sure whether you're referring to the resolution or the order, but I could say that the proposed amounts that are being proposed to be authorized by the corporation have not changed from the original submission, and you need to keep in mind that some of the amounts are duplicative because they anticipate that if bonds are not issued as closing bonds, they could be issued as post-closing bonds. So there is a duplication of amounts. If you add up all the authorizations, they exceed the amount of debt that will actually be restructured, because the proposal contemplates alternative possibilities. For example, bonds could be exchanged. Alternatively, bonds could be refunded. And we include authorizations to allow both of those occurrences to happen, although only one the bonds will only be the refunded bonds of PREPA. Bonds to be defeased or retired will only be defeased or retired through one mechanism or the other. I don't know. I hope that's responsive. But the amounts that have been authorized under the restructuring resolution, I do not believe has changed from the original submission.
Yeah, that was our impression. So we want to confirm for the record that the total amount to be restructured is $6.84 billion.
Excuse me, this is Orlando Figueroa. So I believe the question Mr. Torres is asking is whether through the new proposal there has been a change in the total amount subject to be of debt subject to be restructured or defeased.
Okay, and the answer to that question is no.
Thank you. Mr. Torres, any other questions?
That's it for now. Thank you very much.
Thank you. Is there a representative from Winmar?
Yes, this is Victor Gonzalez representing Winmar.
Do you have any questions for the corporation?
No, we do not have any questions.
Thank you. And finally, Dr. Guillermo Riera, do you have any questions for the corporation? Or first, are you present? Okay, so before we finish, does anybody from the commission have additional questions?
No.
Okay, so this will conclude this conference. Before we finish, we would like to state that in light of today's discussion and in light of the proposal filed by the corporation, the commission will be extending the deadline for the corporation to file its legal brief and supporting documents to on or before June 14th at 4:30 p.m. Similarly, interveners will have until June 16th to file their legal briefs, and general public will also have until June 16th to file written comments. The commission will be issuing an official order or resolution to that effect today. We do ask that all documents that are filed as part of the legal brief, including the brief itself, are filed in a searchable PDF format, so that it would help the commission evaluate them and make sure to include include whatever arguments are made there in its analysis. That being said, we conclude this conference at 11:30 a.m. Please be reminded that we have another scheduled conference for 2 p.m. The number and the dial-in information will be the same for the second call. Thank you all for your time.